afternoon, everyone. My name is Stephen Sapatsis and I'm the Law Institute President for 2016. I begin by acknowledging the traditional custodians of the land on which we meet today, the peoples of the Kulin Nation. I offer my respects to their elders past and present and extend that respect to anyone else with Aboriginal and Torres Strait Islander heritage here today. That acknowledgement can also serve to remind us that we are all relatively recent immigrants to this land. Before I begin, I note that our staff will be taking photos at this event for publication on the LIV Twitter account and other web pages. If you would prefer not to have your photo taken, please inform one of our staff members. We're here today to launch an open letter to the Prime Minister on behalf of members of the legal profession calling for an end to offshore detention. The letter has been signed by almost 50 law firms, representative bodies, legal associations and jurists, many of whom are here today. The letter has generated considerable interest amongst Law Institute members, with feedback given, both positive and negative, but overwhelmingly positive. As a legal community, we have serious concerns about sending people to offshore processing centres. We are concerned that this regime undermines international law conventions, such as the Refugee Convention and the Convention Against Torture. We are also concerned that the offshore processing regime undermines a core requirement of the rule of law, that is, of access to justice. We're here today because, as a legal community, we are concerned that those people in offshore processing centres are being denied a fundamental right. The Law Institute of Victoria has, for a long time, and proudly so, advocated for the rule of law. For the association that represents solicitors in this state, there was a clear and compelling case to become involved and support this initiative. It involves two of the most significant policies of the LIV: access to justice and upholding the rule of law. Our mission statement includes advocating justice for all, and we see this letter as being part of that advocacy. We have been advocating for the rights of asylum seekers, including their access to justice, over a number of years. We acknowledge the role of Nikki Lees, a social justice lawyer at Morris Blackburn, in initiating this letter. The broad support of the letter demonstrates that overwhelmingly the legal community shares those concerns. We call on the Australian Government to process the claims of asylum seekers in line with our international law obligations, and to do this in Australia to ensure that they have access to justice. We have here today three representatives of the legal community who are in support of the letter, each of whom will give a brief talk about why the letter is so important. Our first speaker, Daniel Webb, is a Director of Legal Advocacy at the Human Rights Law Centre. Mr. Webb has worked with the Human Rights Law Centre since 2012 and leads much of its work on refugee rights and the rights of people in all forms of detention. Mr. Webb has been part of the legal team which represented the families involved in the recent High Court case M68. Prior to this, Mr. Webb worked for NGOs and in not-for-profit law for a number of years. In 2010, Mr. Webb was awarded the LIV President's Award for his outstanding work for human rights and social justice. The second speaker, Julian Burnside, AO, QC, needs little introduction. He is an Australian barrister who practices principally in commercial litigation, trade practices and administrative law. He is also an author and a prominent human rights and refugee advocate. Mr. Burnside is a patron of the Asylum Seeker Resource Centre and is known for his opposition to the mandatory detention of asylum seekers, and he has also provided legal counsel in a wide variety of high-profile cases. Mr. Burnside was made an Officer of the Order of Australia in 2009 for service as a human rights advocate, particularly for refugees and asylum seekers, to the arts as a patron and fundraiser, and to the law. Our third speaker, Melinda Jackson, is the Human Rights Law Program Manager and Principal Solicitor at the Asylum Seeker Resource Centre. She was previously a partner at Hannah Jackson Lawyers, a specialist immigration law firm, and has been committed to representing the legal rights of asylum seekers for many years. Ms Jackson has been chair of the Law Institute Refugee Law Reform Committee since the beginning of 2015. In this role, she has contributed heavily to the Law Institute's submissions on law reform, and specifically in relation to refugee law. In July 2015, Ms Jackson was one of the people who led the Law Institute in setting up the Legacy Caseload Working Group to bring together organisations and individuals from the asylum seeker assistance sector to respond to unmet legal needs of asylum seekers in Victoria. After each speaker has spoken, there will be an opportunity for questions, so I ask that you leave your questions until our third speaker has spoken. Having said that, can I ask Daniel Webb to commence? Thank you.
Thank you. Can I begin by thanking the Law Institute of Victoria and also Nikki Leeds and the Social Justice team at Maurice Blackburn for their leadership and initiative in arranging this event and the open letter. And also thank you to the lawyers, the firms, the associations, the academics, the barristers who signed this open letter to Malcolm Turnbull. Since the High Court delivered its judgment in M68 a couple of weeks ago, I've had to make a lot of phone calls to some pretty distraught clients who are very afraid that one day soon they'll be sent back to Nauru or Manus. Now, they are not easy phone calls to make, but it is good to be able to tell them that around the country there are many people who are speaking out in support of them. People around the country who are speaking out and calling on our Prime Minister to let them stay. It means a lot to them to know that we aren't indifferent to their plight. So on their behalf, I also say thank you. Our offshore detention policies show contempt for the basic rights of innocent men, women and children. What we sometimes overlook is that the way these policies are implemented also shows absolute contempt for basic principles of democracy, due process, and the rule of law. And to illustrate this point, I want to tell you about one person who missed out on the chance to be a part of the M68 High Court case that we ran because they were suddenly and secretively deported. We've heard a lot about the 37 babies, the 54 children, the 267 vulnerable people, but I want to tell you something about the woman that we lost. In May 2015, just as we were preparing to file M68, I got a phone call from a really upset and panicked man in Brisbane. He and his wife, who I'll call Sarah, had arrived in Australia on separate boats. He was living in Melbourne on a bridging visa. She was sent to Nauru. A few days earlier, staff at the Nauru camp screened a video of a bellowing Scott Morrison saying, "You will never be resettled in Australia. You can go back to your home country, you can go to Cambodia, but you will never come to Australia." That's what he said in the video. Now, obviously, Sarah's heart sunk. She would never see her husband again. She attempted to take her own life. Thankfully, Sarah didn't succeed. She was evacuated to Australia for urgent medical treatment. Her husband immediately flew up to the hospital to be by her side. He then contacted me and asked if we could help. As it happened, we were about to file a case in the High Court challenging the lawfulness of offshore detention and trying to stop our government from deporting people to it. The case could clearly have benefited Sarah by preventing her return to Nauru. I arranged a legal visit for 4 p.m. that afternoon, but when I called, something wasn't right. I could tell that the phone was on speaker. I asked Sarah if guards were in the room. and a guard stepped forward and announced their presence. I asked them to leave. They said they had strict orders to stay in the room and monitor Sarah because she was on suicide watch. Monitoring her from the other side of the glass door or even turning the phone off speaker weren't options, apparently. I felt I had no choice but to discontinue the call. The legal team, of course, contacted the department and demanded that a confidential legal visit be arranged for the next morning. The department apologised and said, sure, we'll make arrangements for you to speak with her privately the next day. But I woke up the next morning to an email from the Department of Immigration saying, sorry, but Sarah's going back to Nauru. The plane's already in the air. Now that one action from our government, that one action for me encapsulates so much of what is fundamentally wrong with our current policies. They ripped a suicidal woman from her husband and sent her back to the place where she had attempted to take her own life just days before. And they did it in secret, under the cover of darkness, with no transparency and with absolute contempt for her right to access legal assistance. Of course, on a personal level, I then spent many nights second-guessing my own judgment. Was I naive to not anticipate such cynicism, such ruthlessness from the government? Should I just have taken instructions from Sarah about commencing a case, despite the fact that the defendants were in the room at the time? Maybe I should have. But I'll tell you what, from that moment, I knew it was on. We filed for M68, a young mother and her 3-month-old baby, the next day. And for the next 3 months, myself, my colleagues at the Human Rights Law Centre, and fantastic pro bono lawyers around the country identified and advised every single person at risk of deportation to Nauru and Manus who came to us for assistance. If they instructed us, we filed in the High Court an M68 type case, which served to keep them in the country, at least temporarily. Meanwhile, Freedom of Information documents confirmed that at the same time, the government was rushing to deport people as quickly as it could. One email read, the Human Rights Law Centre's filed another case. We need to redouble efforts to remove all transitory persons as quickly as possible, it read, complete with exclamation marks to underscore the urgency of the situation. So we were in a race against time to advise people before they were deported. With great support from many around Australia, we won that race 267 times. Of course, we ultimately lost M68. The majority of judges of the High Court found that our role in offshore detention, our government's role in offshore detention, was authorised by a retrospective law that was passed after the case was commenced. The fact that the gates to the Nauru Detention Centre opened on the eve of the High Court hearing also didn't help our detention challenge. But as gut-wrenching as that decision was, the public response has been nothing short of inspiring. We've seen doctors risk jail to speak out. We've seen churches offer sanctuary to people who are in need. We've seen the United Nations warn our government not to return any one of these people to harm. We've seen every single state premier speak out and call on Malcolm Turnbull to do the decent thing. We've seen the New Zealand Prime Minister join the chorus. Now today, we're seeing the Law Institute and the legal profession do the same. Now these doctors, these churches, these state premiers and these lawyers, they are reminding us of what strong moral leadership looks like. And they are reminding us, importantly, that for all of the huff and puff and white noise about borders and boats, this debate is fundamentally about people. And all people, no matter who they are, or where they come from, or how it is they come here, deserve to be treated with decency and with respect for their basic rights. Now, as a lawyer for many of these vulnerable people, I can't sit back and do nothing while they are returned to harm. We'll continue to do all that we can. But what gives me great hope is that I can see others from different places, from different professions, drawing the same line in the sand. The doctors at the Lady Salento Hospital saying, we're not going to sit back and do nothing while baby Asher is ripped from her hospital bed and sent to a tent on Nauru. A principal at a school in Glenroy saying he will not sit back and do nothing while kids are ripped from his classrooms and sent back to a tent on Nauru. So it is a big moment. Momentum is building. This is by far the best platform we have had in a long time to call for serious, sustainable, long-term policy change. And for the first time in a while, there is a genuine belief that we can win. And so I want to thank all of you and all of the lawyers around the country who've signed on to this letter for being a critical part of that. As big as this moment is, there's many who have been fighting this fight for an awfully long time. That is all that I wanted to say today, but I wanted to hand you over to someone who has been one of the most prominent, one of the most passionate, and one of the most persuasive advocates for the cause for a very long time, someone whose convictions and principles have inspired many others as they've inspired me. Thank you for listening to me, and I look forward to listening to Julian. Thank you.
Thanks very much. I want to start by thanking Daniel and the Human Rights Law Centre and all the lawyers who took part in M68. This could be, can you call it a Pyrrhic loss? I mean, it's a loss which really has taken the whole cause remarkably long way forward, which is fantastic. It's also marvellous to see the range of signatories to the letter. Of course, the letter concentrates, as Stephen said, on the rule of law, and we should all be interested in the rule of law, something which most lawyers are meant to understand and most citizens don't understand at all. But the rule of law has a very interesting recent history in Nauru. Many of you will be familiar with the fact that last year, the Chief Magistrate, by that understand the only magistrate, Jeff Law, was sacked and deported by the Nauruan government because he had made a decision which did not please the government of Nauru. Whilst he was in the process of being deported, the Chief Justice of Nauru, by that understand the only Justice of the Supreme Court of Nauru, Jeff Eames, an Australian, formerly a Supreme Court judge in Melbourne here, Jeff Eames decided to head over to Nauru to try and resolve the problem, and while he was, he granted an interim injunction to prevent Jeff Law from being deported. The government of Nauru deported Jeff Law regardless of the injunction, and then they cancelled Jeff Eames's visa, so he could not return to Nauru, where he is Chief Justice, was Chief Justice. He later resigned his commission. It's hard to think of a more spectacular refusal to acknowledge the existence of the rule of law than sacking and excluding the two principal law officers of the country. But that's what Nauru did. Why Australia is dealing with a country like Nauru is a very interesting question. Frankly, I think we ought to be a little bit more discerning about the countries with whom we deal, even if it's a shabby deal like imprisoning people who've arrived, innocent of any offence, arrived just looking for safety. The government of Nauru has recently been boasting about the fact that the detention centre or processing centre on Nauru is open, and it's not a place of detention. And I noticed that on Twitter, the Republic of Nauru has been widely praising Nauru's conduct. But it remains the fact that journalists can't get there. Journalists from Australia who want to see what's going on in Nauru can't get there. If they apply for a visa, it's $8,000. It used to be $200. If they're refused a visa, they don't get the $8,000 back. So far, the only Australian journalist to have got to Nauru in the last few years is Chris Kenny, who, although he doesn't officially work for the Australian government, is so close that it makes no difference. No lawyers can get there without extreme difficulty, and I know lawyers who've been prevented, including me, from getting there. Amnesty International tried to get to Nauru last year, and they were refused access. You know, here is a place that completely flouts the rule of law and desperately prevents anyone who might look at what's going on from getting a chance to see it. And if anyone in this room thinks that our government is not behind all of that, well then I'd love a guided tour around Cloud Cuckoo Land as well. Amnesty's 2015-2016 report was released today, or is to be released tomorrow. In relation to Australia, it deals with Australia at page 73 and 74, and its headline under the title Refugees and Asylum Seekers, it says, Australia continued its punitive approach to asylum seekers arriving by boat by pushing them back at sea, returning them to countries of origin without proper assessment of asylum claims, creating a risk of refoulement, or by transferring them to the Australian-run facilities in Nauru or Papua New Guinea's Manus Island. By 30 November of last year, 926 people were detained in PNG and 543 people remained in the quote-unquote open facility on Nauru, including 70 children. In March, the government released an independent review of the Nauru Centre which documented allegations of rape and sexual assault, including of children, as well as cases of harassment and physical assault. Now, I received on Tuesday an email from a person who has been working on Nauru and who, despite the Border Force legislation, has had the courage to speak out about what is going on. This person mentioned that at 1 o'clock in the afternoon on Tuesday of this week in Nauru, guards on Nauru cut off the power to a tent in which various women, refugee women, were living. 14 guards stormed that tent, 2 women were strip searched, and communication to the camp had been completely cut. A young woman in the same tent was arrested because she'd taken a piece of fruit from the dining area back to the tent where she was staying. They dragged her by the hair from the tent and beat her up. She later cut her wrists, and after superficial treatment by IHMS staff, she was returned to the place where she had been beaten up. Mr Turnbull, our Prime Minister, has recently said in a doorstop interview in the wake of M68 that this situation is going to be dealt with real compassion, and that we have been exerting ourselves to encourage people to take their children and return to the countries from which they fled. Now, to think of it as compassionate, to force people back to the country where they face persecution is an astonishing misuse of language and a spectacular misunderstanding of what refugee movement is all about. Let us hope that Turnbull's position can be changed. You will recall that the UN Special Rapporteur, Francois Crépeau, I think was his name, was due to visit Nauru last year, but decided not to go because he said the Australian Border Force legislation would effectively prevent any of the people who knew anything useful from speaking to him, except at the risk of 2 years jail. And I'm sure all of you are familiar with the fact that the Border Force legislation, which became law in Australia on 1 July last year, now makes it a criminal offence for doctors in the detention system to report an instance of child abuse or child sex abuse. In civil society, for a doctor to know of a case of child sex abuse and not report it is a criminal offence. In the detention system, it's a criminal offence for the doctor to report it. All of this seems to pass by the majority of people in Australia, but it is profoundly gratifying to see that the doctors are now standing up and speaking out and resisting it. Doctors especially, doctors who work in the detention system. One of them, David Isaacs, has recently sent an open letter to the Prime Minister drawing attention to an article which he had published in the British Medical Journal, in which he tells all of the horrors that are going on in the detention system, and he challenges Dutton and Turnbull to prosecute him for breach of the Border Force Act Section 42. I am pretty confident he's not going to be prosecuted because, of course, the defence of the case would involve disclosing publicly in a court what is going on in the detention systems and in particular on Nauru. But it is profoundly gratifying to see that at the risk of persecution, prosecution and possibly jail, doctors are speaking out against what we're doing in the detention system. It is profoundly gratifying now to see so many lawyers standing up and speaking out against what we are doing, because all lawyers not only recognise the importance of the rule of law, but also recognise simple human cruelty, which is the stock in trade of the detention system in Australia. And the churches are speaking out, and the state premiers have been speaking out, as Daniel said. And let it be hoped that later this year, whenever it is, the voters of this country will speak out. And in case that sounds like I'm speaking against the coalition government, do not be under any illusions at all. The Labor Party have collaborated in all of this. The Labor Party bear as much blame as the coalition, in fact arguably more, because the Labor Party say they think it's wrong, but they do it. At least the coalition believe what they're doing is right, even though it's inconsistent with every principle they stand for. They think they're doing right and they do it. Labor know it's wrong and do it regardless. Both major parties, in my opinion, deserve to be told by all the voters in this country later on this year just what we think about their deliberate policy of cruelty to innocent human beings. Thank you. I now would like to invite, I'm handing over to Melinda. I'm sorry, I forgot doing the handover. Please.
Thank you for that handover, Julian, and it's
yes, very conscious.
certainly a privilege to speak in the wake of such eloquent advocacy from the Director of Advocacy of the Human Rights Law Centre and from Julian Burnside, obviously a sustained advocacy in this space over the course of many, many years. It's also a privilege to speak on behalf of the Law Institute of Victoria, and I must say I'm immensely proud of our Law Institute. I think that the commitment to pro bono and to the rule of law and to fundamental principles is strong in Melbourne. It is certainly gratifying to be here today and to be Chair of the Refugee Law Reform Committee and to be able to advocate fearlessly in this space. It can be a space where lawyers are sometimes reluctant to enter into the political space. Of course, the previous speakers certainly weren't, but it's something that I'm very proud of the Law Institute for its courageous approach to the rule of law, to adherence to international obligations, and to being able to speak publicly and privately on this issue. The Law Institute of Victoria and the Refugee Law Reform Committee believes that the current situation for refugees in Australia significantly departs from the rule of law, as my previous speakers have already touched on. And I'll briefly mention three glaring examples of how the current system is departing quite radically in this way. That's first of all the retrospective laws that are affecting our clients on a daily basis. Secondly, the offshore processing regime itself and the denial of access to justice in that regard. And thirdly, the transfers within Australia, within the detention network, which extends beyond the 267 and the cohort that are subject to transfer back to Manus or Nauru, to offshore systems, but is affecting our ability to access our clients on a daily basis. Firstly, retrospective laws affecting our clients. We had a fantastic example of this in the case of M68. I'm sure Daniel's acutely aware that the government passed a number of retrospective amendments after the case had been filed. Firstly, to fast-track legislation through regarding the funding for offshore detention regime, and just 2 days before the High Court handed down its case, opened up the centre to be a vast 21 square kilometres where refugees could roam freely and be free to be abused throughout the land of Nauru. Shifting the goalposts is a fundamental breach of the rule of law principles, which require that the law is both readily available, clear and accessible. The Legacy Caseload Act also brought with a number of retrospective laws which affect people significantly who arrived in Australia between the 30th of August 2012 and the 31st of December 2013, but also for people who arrived before that date, who, for example, had their visas arbitrarily converted from permanent applications into temporary visa applications, and many of those, around 6,000 people, are still waiting for an outcome despite waiting for over 4 years. The Legacy Caseload Act radically changed the refugee status determination process, which will be familiar to you all, and significantly derogated from our international law obligations. In particular, regards to the definition of a refugee, in regards to fast-track processing and removal of merits review, short timeframes for response and limited opportunities to introduce new information. These changes have practical and detrimental effects for our clients and for the lawyers who are trying to access our clients. They are complex and confusing, and in our view breach the rule of law principles that the law should be clearly known and accessible. Combined with the removal of almost all government funding for asylum seekers, and the fact that the new scheme is only the pay scheme has referred only several hundred people out of the 24,000 people that need to be processed, there is a present and serious risk of denial of access to justice. Denial of access for justice, let us remind ourselves, is a significant thing for asylum seekers who may not be able to tell their story, and may be, for our clients, the difference between life and death. The second topic I'll cover is the offshore detention regime, which has already been dealt with in some detail. There are three serious problems with offshore detention. Firstly, that it allows the government to make decisions which are politically expedient, and that our clients are then out of sight, out of mind, and the political objective can be therefore achieved. Secondly, that the offshore detention regime itself is being internationally criticised as breaching international obligations, which Australia has voluntarily assumed, and that transferring people back to Nauru from Australia would put Australia, in the UNHCR's opinion, at risk of breaching its obligation not to return people to cruel, inhuman or degrading treatment under the Convention Against Torture. We are talking about torturing people, potentially torturing people, returning them to torture. This is something that is fundamentally grievous. In relation to the international law position of offshore detention, there were some glimmers of hope, as you probably know, in the M68 case. The court, all judges, possibly with the exception of Justice Keane, held that Australia is responsible for the detention of people on Nauru itself, or had otherwise been implicated in their detention, despite the move to an open centre. The case also picked up on principles in S4 and said that the government cannot support an offshore detention regime that goes beyond what is reasonably necessary for processing. And again, the principle of rule of law, that executive power is subject to appropriate oversight and to our voluntarily assumed international obligations, is clearly thrown into sharp relief. The LIV calls for asylum seekers, as Stephen mentioned, to be processed in Australia efficiently and humanely and in accordance with our human rights obligations. Thirdly, in relation to transfers between detention centres, the Department of Immigration colloquially called the detention network in Australia, which makes it sound like a very nice place to be moved around. Transfers between detention centres in Australia and also to Christmas Island have become a feature of representing clients in detention over the last few years, but particularly escalated since 1st of July, when Border Force officially commenced as a militarised arm of the Department of Immigration. The transfers are concerning, obviously, for several reasons, particularly in relation to use of force and restraints during transfers. People are usually transferred between the hours of 3 and 4 a.m, as many of you may know, and usually restrained using handcuffs, even young women. But transfers are also concerning because it denies access to legal representation. Lawyers in the LIV's committees and working groups have reported that clients are transferred during court proceedings in clear contempt of court, during application processes, during appeals, and including right before their departmental interviews. With only a handful of not-for-profit organisations, including my own, the ASRC, and there's usually only 1 or 2 CLCs in each state that are able to provide access to legal representation, that access is often thwarted, almost always, by transfers within the detention network, and particularly to Christmas Island, where the technological facilities themselves make it impossible to represent clients freely. Border forces impose processes for booking appointments, visiting clients, and as I said, the technology and the facilities themselves, where guards may be in the room with your clients or the walls are completely non-soundproof. It is practically impossible to represent your clients freely. The transfer decisions are also difficult to challenge in court, with the Department, Border Force and the various subcontractors in this detention network pointing at one another and citing operational reasons. And so we're yet to ventilate these important issues of denial of access to justice and the contempt of court. It's the LIV's view that everyone should have access to competent independent legal advice, and particularly in the complex landscape that we're operating in today. Refugee lawyers are dealing with a complex and constantly shifting legal landscape which would be impossible for asylum seekers to understand. We once again reiterate that we hope, on behalf of the LIV, that of course the 267 people are allowed to committed to remain in Australia, but also that offshore detention as a regime ends. The LIV believes that people in Australia who are currently awaiting over a protracted period, years for processing of their refugee applications, are processed efficiently in line with the rule of law principles and our international obligations. Thank you.
We as lawyers play a really important role in upholding and promoting the rule of law. We've heard from three very experienced practitioners today who've shown us that perhaps for a country that is fundamentally caring and compassionate, we've made it a little too difficult for people to access justice, and this undermines the rule of law. Three experienced speakers, Daniel Webb, Julian, Burnside and Melinda have given us a real insight into the practical effects of certain of the government legislation. Join me in thanking them for those insights today. We have a few minutes for questions if anyone has questions. We have some roving microphones. If you do have a question to ask, could you please identify yourself and identify to whom you're directing your question. Thank you.
Hello. Can you hear me? I'll just yell. In the M68 decision, of the judges who found that that offshore processing was valid and said that that's only as much as it's connected to a regional processing system, were there any other kind of limits or checks that they spoke of around that, or was that it only extended that far?
I think it's a time and purpose limitation. So if and that's both statutory and constitutional. So the legislation that the majority found authorised our government's involvement in detention is confined to conduct connected with regional processing and previously articulated constitutional limits on executive detention state that detention is authorised when it's reasonably connected to the purpose of facilitating entry or removal from the country. So basically, whether you look at it from a statutory construction point of view and this retrospective law, or a constitutional point of view and the limits on executive power, there are limits on our government's ability to lock people up here or elsewhere, and those limits relate to the length of time that they're held for and the purpose for which they're held for. So it opens up a few possibilities. I mean, if you sort of imagine situations when someone might have been on manus for years and not much has happened with their processing, questions might emerge about whether their detention is lawful. But that's something that myself and many others are going to have to look at in a bit more detail in due course.
I would wish you luck with that. I know one Sydney-based barrister who has tried to set up litigation in PNG in relation to detention in Manus. He was removed from the detention centre at gunpoint by PNG police. because he was trying to help represent people.
Thank you.
Hi, Josh Taylor. I'm a journalist for Crikey. The government's consistent line on the M68 case has been if the government, if advocates and the media go quiet about this, that it can be dealt with on a case-by-case basis, and it would be much better for the 267 involved if we all just shut up. What is your response to that?
I don't think any of us believe that. It would be apparent that if we kept quiet, many more human rights abuses would be happening in immigration detention centres offshore in Australia. I don't buy that. In our experience, many things left covered up are the dirtiest of all.
On the other hand, I think it's plausible in the current environment to say that the government would not wish to be seen doing anything that looked humane or decent.
Yeah, I hear those statements and they amaze me. I mean, there's obvious self-interest in the government saying that. They'd love it if we all just stayed quiet and they could do whatever they wanted to vulnerable people. We can't do that. I take Baby Ash's case as an example. We wrote to the government repeatedly saying, please just agree that if you are going to deport this child, you will let us know. And they refused. It was only when the case became public, it was only when we filed again in the High Court that they said, okay, we'll agree to give you 3 days notice before we deport this kid. So the quiet way doesn't work. And the third point I'd make is think about that statement. What they're saying is, we'd love to be kind to people, but there's political capital in us seeming ruthless. So we want to be nice, but we don't want to own it. And I just think, I mean, if you want to be decent, do it. Do it because it's the right thing to do, irrespective of whether it's popular. That's the nature of leadership, that you shape public opinion. You don't just passively and frightenedly react to it.
Do you have any other questions? If not, we might draw the discussion to a close. Thank you for the question. Sorry, we do have another question.
Hi, Josh Adler from Herbert Smith Freehills. I just wanted to touch on Sophie's first question there about the time and purpose, and then you touched on the time and purpose as being sort of the legitimised from the M68 decision for the holding in the offshore detention. What I want to do is just query or get your thoughts about how that sort of links in sort of more broadly to previous decisions that the High Court's found down in relation to indefinite detention for those that don't have citizenship or a home country to return to, such as in the Alcatel decision, and how, I know that it deviates from the 267 in this case, but if that was to arise again in future, how would the time and purpose test apply to prevent indefinite detention continuing?
I'm aware that there's very eminent senior counsel on the panel with me, and I feel like they're very well placed to take that question. But I think in some decisions recently, S4 in particular, there's a bit of a message from the High Court that this is not a blank cheque. You can't just lock people up forever and do nothing. Detention is lawful if it is for a lawful purpose and you action that purpose. If it's for the purpose of processing, process. If it's for the purpose of removal, remove. But if you go beyond that, if you just leave people languishing there for ages, we're prepared to look at the boundaries of executive power to keep people held. I think the trouble with those arguments, and many lawyers would have experienced this, is that they depend on individual circumstances. How long has this person been locked up for? What steps has the government taken to process this person? And the best cases, you file, they're released. So there is some hope from the High Court that these principles are going to be applied to rein in executive detention. Getting the right case at the right time before the court is the challenge.
As you mentioned, Alcatel presents difficulties, and for those who aren't familiar with the Alcatel decision, Alcatel was a stateless Palestinian who had been rejected as a refugee but couldn't be removed because there was nowhere to send him. And the High Court in early 2004 said in substance, well, that's okay, you can stay in detention forever. My impression, especially from S4, is that the High Court is ready to say, well, Alcatel is no longer the law in this country. Now, I don't like trying to predict the outcome of High Court applications. None of the members of the court who sat on Alcatel are still on the court, so it's really hard to tell. And I'm not going to the numbers game predicting, but it's such a terrible decision. It really is the Dred Scott decision of our High Court, and I hope that one day it'll be kicked overboard. But as Daniel says, you've got to get the right case for the right circumstances, and he's exactly right. When you get a case that really makes you recoil and say, well, how can this possibly be, then the department behave themselves. There are two groups for which these problems emerge, and neither of them are particularly sympathetic groups. One is for Iranians who've been rejected in their refugee claims. Iran does not accept returns unless they're voluntary returns, and given the way in which refugee status processing happens at the moment, it's not at all difficult to see that there will be some Iranians who are rejected in their claim for protection who are nevertheless too frightened to go back. They face the prospect of staying in detention for good because they can't be returned, they're not going to be let out, and they're being gradually concentrated up at Wickham Point out of Darwin. And I'm aware that they are being increasingly pressured to agree to go back. And that in itself may give rise to an interesting bit of litigation. The other group, also not very sympathetic, are those who've been adversely assessed by ASIO. And if they're adversely assessed by ASIO, they must be refused a protection visa, even if they're assessed as refugees. And the interesting thing about them is that ASIO steadfastly refused to let them know the basis on which they've been adversely assessed. So you've got people right now who've been in detention for years, and they have not the slightest idea what facts were taken into account in order to adversely assess them and deny them the protection that they're otherwise entitled to. Now, again, because of the security element, they're not sympathetic cases. You know, they're not mothers with babies. Well, actually, one of them was. But they don't attract the sort of sympathy because of the security aspect. So it's kind of hard to see whether we get a breakthrough on that or not. Until then, we just have to sit back and reflect on what you get with an old-fashioned constitution with nothing better to lean on in these circumstances than the separation of powers doctrine. Nothing like human rights protection.
Thank you, Julian.
I was simply going to reflect that very quickly, that when we're looking for test cases, that it seems a bit extraordinary and kind of grotesque that we're waiting for the worst cases in terms of human rights abuses or indefinite detention prospects to walk through our doors, and that those might be the people that we can take to the High Court to revisit a bad decision. It does seem quite extraordinary that we're having to wait for those, for the individuals. They are in the most horrendous of circumstances, and they are our best test cases. It's an interesting thing as a human rights lawyer, I'm sure one that you will grapple with.
Incidentally, if I can just add to that, it's not well known about Alcatel, but Alcatel had been released into the community because of the full court decision in Al-Masri. Al-Masri was on his way to the High Court when he was able to be released, and so Alcatel's case was slotted in on the High Court list. But because of Al-Masri, he was in the community when his case was decided. Now, Amanda Vanstone's not my favourite person, but she was the Immigration Minister at the time, and the day the High Court decided Alcatel, she granted him some questionable sort of visa so that he didn't have to get taken back into detention and stay there for the rest of his life, and he subsequently became an Australian citizen. So in a funny sort of pragmatic way, we got to a decent result without acknowledging that decency was any part of it.
Thank you again. If there are no further questions, we have time. Please.
Benjamin Melinda is my name. I'm a barrister. And I was in Nauru at the end of 2014 appearing for some asylum seekers that were charged with riot and unlawful assembly and arson of the detention centre 12 months earlier. So we had about 50 clients who were involved in that event. My question now is what at that time they were all in detention, obviously in the RPC 1, 2 and 3. Now that they've been undetained, that the gates have been opened, so to speak, and it just seems a bizarre concept to me, having been there for a couple of months, that the gates can be conceivably opened on an island that, as has been mentioned, is only about the size of a pimple on your bum. It's a very small place. It's a dangerous place. It's a dangerous place for Nauruans because when you are released from, when you're not in the detention centre, you are subject to all sorts of threats, including the fairly mundane problem of the wild dogs that roam freely around Nauru. The problem, it seems to me, is that the notion of being detained is that they are left in Nauru, not in the detention centre. I had a couple of clients, and I think I'm breaching the Border Control Act at the moment, but I had one client at least who, or couple who had escaped the detention centre while they were in detention at RPC 2, they were single males. They escaped by simply walking out because there was no real fence around the edge. They walked out onto the phosphate remnants. They went around the island for about 2 hours, found that there was no water available, that there's no food that they can really go to the local shop and buy, or indeed steal, because there are no crops grown on Nauru because Australia's nicked all their phosphate and the mountain's just not there. With all of these problems, they decided after 2 hours that life was better in the detention centre, so they turned around and went back. Back to the detention centre, where at least they had showers and food and water. So my question really for the panel is, have they really left detention?
I was going to add Brendan as our fourth speaker, really.
I think it's an interesting argument under international law whether it's still detention. Nauru's the same size as Melbourne Airport. But I think the sort of, legal technicalities aside, and I know we're a room full of lawyers and we like to focus on them, my main concern is the injustice we're inflicting on these people. And that injustice was never that they were trapped behind a fence. It's that there are real safety issues and no life for them on Nauru beyond that fence. I think the government itself recognises it's unsustainable to leave all of these people languishing on a tiny island, which is why it's prowling around our region, looking at Cambodia and the Philippines and who knows where else to send them. It knows that it cannot warehouse people on that island forever, which is why I think it would be particularly senseless to send 267 more people back down that road that they know leads nowhere.
I think you're right. I think they're still detained. It's like Devil's Island, really.
Is this a legal opinion that I can
Yeah. Incidentally, you're not caught by Section 42 of the Border Force Act because you learnt that stuff before it came into force, and you were not there as an entrusted person because you weren't working for the department or one of the subcontractors. So I think you're okay.
Can I share a cell with you?
Thank you. We're going to wind up now. The Let Them Stay letter will be put onto the LIV website probably from this afternoon. We will update it with any new signatories to it. If you're here today and you want to sign up to the letter or represent an organisation that wishes to do so, We have some LIV staff at the back of the room, and they can take the details and update the signatures on the letter. Otherwise, I thank you all for attending this forum today. Join me again, please, in thanking the speakers. And otherwise, I'll bid you good afternoon.